Uh, Your Lordship, the coach's mic is on mute.
Yes, my lord. Much obliged. Please.
The respondent.
Yes, some written arguments were directed to be filed, Your Lordship. Pay for a small accommodation. Oh, okay. I'll argue the matter, a date may be given.
We have filed.
Please, Your Lordship, because
We have filed, respondent has filed. Your Lordship. Okay. 22nd, if it, 22nd, if it can be taken. Yes, sir. Yes. Obliged.
in these matters, Lordship, if you look into the owner's definition under the Motor Vehicles Taxation Act, I am ready. Very short question is involved. In fact, now the person who has purchased that vehicle is not served in some of the matters. It is a very short question, Lordship, but the receipt is there brief. Petitioner, bank, appellants. If it is passed over also, I'll argue the matter.
Appear for appellant, Your Lord. Your Lordship, appear for appellant, Your Lordship, there is no requirement for filing any compilation transfer pricing issue, my lord. Once that judgment is released, it will have a bearing, my lord. It may be caught up in due course after release of that. Please, my lord. Please. Yes, my lord. Other cases.
For responding in this matter. ಅವರು ಇದು ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡ್ಬೇಕಾಗಿದೆ ಸ್ವಾಮಿ ಅದು ಸರ್ಟಿಫೈಡ್ ಒಂದು ಕಾಪಿನ ಲೆಜಿಬಲ್ ಇಲ್ಲ ಅಂತ ಫಸ್ಟ್ ಬೆಂಚ್ ದೇ ಹ್ಯಾಡ್ ಸಾಟ್ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ದಟ್ ಈಸ್ ನಾಟ್. ಇಲ್ಲ ಅದು ಯಾವುದೋ ಒಂದು 2-3 ಪೇಜಸ್ ಇದ್ದಿದೆ ಅಂತ ಮಧ್ಯದಲ್ಲಿ ಇದಾಯ್ತು ಅಂತ ಲಾಸ್ಟ್ ಟೈಮು ಹಂಗೆ ಇದು ಮಾಡಿದ್ರು.
I'm appearing for the appellant. 6.1, the question of law has been framed, and 6 has been tagged with 6.1. Your Lordship. The only difficulty, Your Lordship, is that I'm not able to get the case laws also because I'm shifting my office. It can be taken for file hearing the week next, I would argue.
Week after next, on request.
Oblige, Your Lordship. Thank you.
Filing, filing, written submission, etc. is dispensed with.
Yeah, oblige.
Okay. Dilip ಏನಿದೆ?
AC is appearing, Manoj. Manoj, one more submission, Manoj, it's for awaiting tribunal records.
ಎಲ್ಲಿಂದ ಬರ್ಬೇಕು? ಟ್ರೈಬ್ಯುನಲ್ ಎಲ್ಲಿಂದ?
ಇಲ್ಲೇ ಇದೆ, ಬ್ಯಾಂಗ್ಳೂರಲ್ಲೇ ಇದೆ.
ಬೆಂಗಳೂರಿಂದ. ಯಾಕೆ ಯಾವಾಗ ಕಳಿಸ್ಯಾರ ಇಂಟಿಮೇಶನ್? when intimation is sent. In all matters, Supreme Court said in 1953 or 54, in all certio matters, automatically lower court record should reach the High Court. Then pending consideration before the apex court.
Please, my lords, that
11/11/24, all right, but after 16/12/24,
please, my lords.
you have
similar-
said that matter is being debated before on the
Please, my
floor of
lords,
the
my
apex
lords,
court.
please, my lords. My lords,
Call the after 4. Is it true or is there is any change?
it is, my lords, it's yet to be decided by the honorable apex.
All right, Barkali.
My lords, one submission, lordships may kindly have a short date, my lords, because we are telling, my lords, we can distinguish that decision of Delhi High Court, which is in challenge before the apex court. My lords, this case has been handled by ASG, my lords. Any date, my lords, next week or week after that, my lords, because there is a lot of matters pending before the tribunal, my lords, on this particular issue. And
Learned panel counsel appearing for the appellant submits. ಅವ್ರಿಗಿಂತ ಮೊದಲೇ. A coordinate bench of this court wide order dated 16/12/2024 had said as under. Next paragraph. Learned panel counsel appearing for the appellant submits. The issue being debated on the floor of the apex court is bit different from the one involved in this case. And therefore, hearing need not be deferred. Full stop. Next, in view of the above, call this matter. Yavaga.
lordships, I'll inform the date, my lords. I'll check with ASG, my lords.
Your friends, so which date will be convenient to you? Because it should be convenient to them. Are you coming from outside? You're from here only.
Senior counsel Shankar sir appears. I'll
This
check
matter.
with, please, my lords. I'll
Tell one
check.
date kodi.
Please.
Post on. Next.
Oblige.
Yes. Then the off ಆಗಿಲ್ಲ. What up, sir? Ravindra? Then off ಆಗಿದೆ. ಏನಂತೇನು? Okay. Ah.
9 and 10 are connected matters, my lord. I pray for 2 weeks time to file better affidavit, my lord.
ಏನದು better of
300 days delay ಇದೆ, better affidavit file ಮಾಡ್ತೀನಿ.
2023 matter.
Your lordship, anyhow, the matter is pending before the Supreme Court SLP, whether
Will condone the delay.
ನನಗೆ ಕಾಪಿನೂ ಸಿಕ್ಕಿಲ್ಲ
ಅಲ್ಲ,
ಸರ್. I just want to file copy.
ಯಾಕೆ ಹಾಗೆ ಮಾಡ್ತೀರಿ ಎಲ್ಲದರಲ್ಲಿ?
ಇಲ್ಲ, ಇದ್ರಲ್ಲಿ ಡಿಲೇ ಹೋಗಿತ್ತು, ಅದು ಮಿಸ್ ಅಪೀಲ್ ಮೆಮೋ ಜೊತೆಗೆ ಹೋಗಿರ್ಲಿಲ್ಲ ಅಂತ ಕಾಣಿಸುತ್ತೆ. ಐ ವಿಲ್ ಫೈಲ್ ಇಟ್,
ಕೊಡಿ ಕಾಪಿ.
ಬೆಟರ್ affidavit ಜೊತೆಗೆ ಕೊಟ್ಬಿಡ್ತೀನಿ.
ಅವ್ರಿಗೆ ಏನೋ ಕ್ಲೈಂಟ್ ಕೇಳಿದ್ರೆ ಏನು ಉತ್ತರ ಕೊಡಬೇಕು.
ಬೆಟರ್ affidavit ಜೊತೆ ಐ ವಿಲ್ ಗಿವ್ ಇಟ್.
Counsel for the appellant, panel counsel for the appellant seeks 1 week for filing better affidavit in support of application in I number 1 of 2024 that seeks condonation of delay of 299 days proved in filing the appeal. First up, call after 2 weeks.
Great.
Appellant to serve copy of the application along with the affidavit and the additional affidavit on the counsel representing the assessee.
9, 10 and 11, my lord.
9, 10, 11, same orders. ಅಲ್ಲಿ days ಮಾತ್ರ change ಆಗ್ತದೆ. ಎಲ್ಲ 299 ಇದೆ ಏನೋ?
ಇಲ್ಲ,
470 ಇದೆ.
ಇದರಲ್ಲಿ 470 ಇದೆ.
ಒಂದರಲ್ಲಿ 11ದಲ್ಲಿ. Okay.
Your lordship,
Ah.
Your lordship, he is not in station, my lord. It may be kindly adjourned for 2 weeks. He is also required to file better affidavit, my lord.
All right. Call after 2 weeks for filing a better affidavit, better stroke additional affidavit as on
Additional.
file by counsel for the panel counsel for the revenue.
Your lordship, filing of return submission may be kindly be dispensed with first.
Dispensed it,
Dispensed.
Admission ಗೆ post ಆಗ್ಬೇಕು.
It may be posted for admission, my lord.
admission, post for admission.
I pray for 2 weeks time, my lord.
Lords, in this, actually, I am seeking time because I have to file my statement of objections, my lords. 1 week's time. Sent it to the client.
Affidavit, better affidavit ಹಾಕ್ಬೇಕೇನೋ? ಹೌದು.
Better
ಯಾರು ನೀವೇ
affidavit-
ಹಾಕಿ
Yes, my lord.
better affidavit.
ಇದ್ರಲ್ಲಿ
to be
better
filed.
affidavit ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಹಾಕಿದ್ದಾರಾ?
ನಾನು objections file ಮಾಡ್ಬೇಕು.
Call this matter after 2 weeks at the request of counsel for the assessee. Okay.
My lord, copies have been served.
Copy serve ಮಾಡಿರಾ?
ಮಾಡಿದ್ದೀವಿ.
Yeah, you are appearing for the assessee.
Yes, my lord.
Yes, sir.
Yes, my lord, our written submissions are also, my lord, served on them. We couldn't file it in the registry. We are carrying them, my lord. We can file them in the registry or I can hand them over, my lord.
Very well. You can hand them also, but after arguing, we have to argue this matter because.
Please,
we should not-
absolutely.
Ready?
ಇಲ್ಲ, that may be fixed. ಅವ್ರು ನೋಡ್ಕೊಂಡಿದ್ದು. There's a lot of agreements are
In
involved.
fact,
in
my
this.
lord, they had filed the writ appeal on the basis that a learned single judge had followed a division bench judgment of this court. They say it's incorrect because they had filed a review petition. Review petition stands dismissed now.
Okay. Is it true? Then what
I came
remains?
to know, I'll just look into the records, my lord, I'll make my submission. Date may be fixed.
It's
Yeah,
there in the
yeah,
writ
any-
appeal.
any
They
date.
pleaded that. They pleaded that and now the review is dismissed.
No, if you are, if you have preferred this in contemplation and hope of succeeding in review and review is rejected,
I'll go to.
what should happen to this man? Nothing remains.
A date may be fixed.
Yeah,
Any date.
fixed. Other date may be fixed. Argue the matter. Date may be fixed. Trial law. Argument. ನೋಡ್ಬೇಕು.
ನೋಡ್ಬೇಕು ಅಂದ್ರೆ Lordship's kind ಯಾಕಂದ್ರೆ will-
uh,
ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಇದೆ ಇದೇ ರೀತಿ If we your are just With your lordship's kind will, this matter is also identical to serial number 24 and 25 listed today, my lord.
Call this matter along with 24 and 25.
Your
Which date will be convenient to you, sir?
My lord, if in February sometime, my lord, 10th or
Use any
17th,
date of
Monday,
your
any
choice.
Monday, my lord, 10th or 17th, whichever is convenient to your lordship.
17th,
17th, Feb.
Any other date, my lord, other than.
then 10th,
10th.
10th of February.
10th of February.
10th of
Your
February.
lordship, in serial number 24 and 25, my lord.
Huh.
Income tax separate tribunal records may be secured.
First up, in the meanwhile, records from the tribunal shall be secured without fail. And failure may result into disciplinary action against the concerned lapsing official of the registry. Okay. Very well, sir.
Obliged.
Okay.
My lord, I will file a written submission in the meantime.
After filing of, after arguing the matter.
Oh, we can file it now. It's ready.
But how,
We've-
unless we hear the matter?
All right.
Suppose you have framed it in a way that the other bench had.
Can
heard
do that.
In
We'll-
that way.
If
you want to.
required, we'll tender it on that day. If not, my lord, then
Very
we'll
well,
argue it.
no issue, same day. I'll not dispense with ಮಾಡ್ಕೋಬೇಕು. Yes,
I beg to appear through VC, Your Lordship, in item 16.
we beg to hear you.
Deeply obliged, Your
You
Lordship.
need not beg at all. It's your right of the bar to address the court.
Obliged, Your Lordship. Lordship, we understand that the registry has pointed out a defect that the second copy of the writ petition is to file. We'll cure that, Your Lordship.
You have filed it now, not yet filed.
Your Lordship, pilot, we just came to know from the cause list that since earlier this matter was listed before the learned single judge and it was directed to be posted before the DB. Therefore, I think there's one copy is missing. We'll file that. We'll comply with that order.
The compliance within 2 weeks. 2
Obliged.
weeks. At the request of Shri so and so.
Harpreet Singh.
Them ಹೆಸರು what, please tell your sweet name.
My colleague is there, Your Lordship.
I'll give.
Okay, okay. All right. From Delhi?
Yes, Your Lordship.
Delhi, what is the weather condition there?
Chilling, Your Lordship.
Chill.
Deeply obliged.
Very well. Okay. Mr. Tiwari,
Your lordship, I pray for time, my lord. He is not in station, but he has to file a better additional affidavit, my lord.
additional affidavits to be filed within 2 weeks. Okay. Finally. Time ಕೇಳಿದ್ರು.
Your lordship, they have to
Tanmay.
file.
Tanmay, you took that time, na?
Lordships, I have not been able to file the statement of objections.
2 weeks?
Yes, my lords.
2 weeks at the request of Tanmay. Yes.
19, I pray for a week's time. 1 week time may be granted.
Complaints of office objection. There are two, dispenser returned with office objections and 2 of yes, compliance within 2 weeks.
Please. 20, my lord. Your lordship, he has to file additional affidavit, my lord. Pray for 2 weeks time, my lord.
2 weeks for filing additional affidavits, finally.
Your lordship, prays for a week time, my lord. Non-filing of.
Non-filing of reply. Reply ನೀವ್ ಹೆಂಗ್ ಬರ್ತೀರಿ ಅದಕ್ಕೆ? IA 1 of 2024 by ಯಾರು respondent ನಿಂದನಾ?
Respondent.
ಏನದು IA?
IA for condonation.
Your Lordship, I appear for the respondent.
Yes, sir.
Your Lordship, I am appearing for the respondent. On 2nd of December, the Honorable Court had directed Department to serve upon us the IA application. We have been served yesterday only. So therefore, pray for 4 weeks to file our reply, Your Lordship.
All right. What is that IA 1 of 24 by you?
Your Lordship, 103 days delay, my lord.
IA 1 of
The delay, just 103 days delay, my lord.
IA is filed by respondent.
There's no IA by respondent, Your Lordship.
there is
It's
no-
filed.
It's IA filed by the appellant itself, my lord. For delay.
Wrongly ತೋರ್ಸ್ಯಾರ ಇದಕ್ಕೆ apply ಹಾಕ್ಬೇಕು ಅಂತ ಅನ್ಕೊಂಡು. It will give time, na? Because you have served it only yesterday.
Yes.
Yes. 2 weeks for filing reply.
Your Lordship, may I request for 4 weeks?
4 weeks, IAಗೆ.
Your Lordship, on 2nd
4
December, 4 weeks were given in
Ah.
the order. It's noted in the order also.
All right, 4 weeks. As
Much
requested
obliged.
by counsel appearing for the revenue. Okay.
Sir, I filed the PF, sir.
You have filed it.
Filed, already filed. I'm having the acknowledgement also.
We can hear a groundless lawyer, but there should be ground in
Sir,
the
I-
matter.
no, no, I-
Where is your,
I was sick. On 9th, I came to Bangalore. By the meantime, huh?
where is your uniform?
Sorry, sorry.
ಮತ್ತೆ
ಇಲ್ಲ,
Anyway,
ಏನಂದ್ರೆ
ಏನಿದೆ ಏನಾಗಿದೆ?
ನಾನು ಬಹಳ ಸಿಕ್ ಆಗಿದ್ದೀನಿ. ನಾನು ಒಂದು ಮೆಮೊ ಕೊಡ್ತಾ ಇದ್ದೀನಿ. ಆ ಅಡ್ರೆಸ್ ಅಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್.
ಸೆಕೆಂಡ್ ಸೆಟ್ ಕೊಡಿ ಅದನ್ನ. IA for recalling second set ಕೊಡ್ಬೇಕು. ಅಲ್ಲೇ ಹಾಕ್ಬೇಕು, ಇಲ್ಲೆಲ್ಲ ರಿಜಿಸ್ಟ್ರಿ.
ಮೆಮೊ ಕೊಡ್ತಾ ಇದ್ದೀನಿ. ಆ ಅಡ್ರೆಸ್ ಅಲ್ಲಿ ಅವ್ರು ಇಲ್ಲ ಅಂತ.
ಯಾರಿಲ್ಲ ಅಂತ. ಅಲ್ಲ ಸೆಕೆಂಡ್ ಸೆಟ್ ಹಾಕ್ಬೇಕಲ್ಲ. ಕರೆಕ್ಟ್ ಅನ್ರಿ?
ಅಲ್ಲ ಇದರಲ್ಲಿ may I submit, my lord? This is a writ appeal against the order passed under Article 226 of Constitution of India. The lordship has observed that whether to hear on maintainability of the writ appeal.
That is stayed, na? That judgment is stayed now. We held appeal is maintainable and hold ಮಾಡಿದ್ವಿ. That matter is pending before the Supreme Court now.
Supervisory jurisdiction,
Eh?
there is a 3 judges bench, my lord, judgment. In Radhesham case,
Tammanna, we considered,
please, my lord.
then we passed an order in Dharwad, holding that Tammanna does not correctly lay down the law, though it is by a very big bench. I think 7 judges. Tammanna versus Renuka. It's 7 judge bench judgment.
Of our own high court.
One ನಿಮಿಷ ಇರಿ. ಅಲ್ಲಿ ಬನ್ನಿ, ಆ ಕಡೆ ಬನ್ನಿ. ಇಲ್ಲಿ ಬರ್ಬೋ. You are not supposed to come to the well of the court. It's well of the court. You are not supposed to come there. Now,
ಅಲ್ಲ,
that judgment where we held this judgment to be per incuriam is being considered by the apex court by 5 judge bench.
Please, my lord.
So because of that maintainability issue may not arise.
Please, my lord.
So we will await judgment of the apex court. In the meanwhile, what needs to be done by him? ಯಾರಿಗದು? Steps ತೊಳಿ.
ತಗೊಂಡಿದ್ದೀನಿ ಸರ್ ನಾನು.
ತಗೊಂಡಿರಾ?
ಆಲ್ರೆಡಿ ಫೈಲ್ಡ್. ಮೋರ್
Steps.
ದನ್ ದಟ್ ಸರ್, ತಮ್ಮಣ್ಣ ಅಂಡ್ ಅದರ್ಸ್ ನಲ್ಲಿ ಇನ್ವಾಲ್ವ್ ಆಗಿರೋ ಮ್ಯಾಟರ್ಸು ನನ್ನ ಕೇಸಿಗೆ ಅಪ್ಲೈ ಆಗಲ್ಲ. ಈ ಕೇಸಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಯಾವುದೇ ಆರ್ಡರ್.
ಸ್ವಲ್ಪ ಅರ್ಥ ಮಾಡಿಕೊಳ್ಳಿ. Appeal is maintainable or not is the question. ಏನಾರ ಒಂದು argument.
ದಟ್ ಈಸ್ ಮೇಂಟೈನಬಲ್ ಸರ್.
That's what you are saying. But Tamanna says
Office has wrongly put that objection.
that objection is not maintainable.
ಮೇಂಟೈನಬಲ್ ಸರ್.
ಯಾಕೆ?
Because
Order ಏನದು?
ನಾನು ಯಾವುದೇ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಪಾಸ್ ಮಾಡಿದ ಆರ್ಡರ್ ಮೇಲೆ
ಬಂದಿಲ್ಲ.
ಬಂದಿಲ್ಲ. ನಾನು ಬಂದಿದ್ದು ಫಾರ್ ಸ್ಪೀಡಿ ಡಿಸ್ಪೋಸಲ್ ಆಫ್ ಮೈ ಕೇಸ್. ಯಾಕಂದ್ರೆ ಅಲ್ಲಿ IA ನಂಬರ್ 15
ನಿಮ್ಗೆ ಸ್ಪೀಡಿ ಡಿಸ್ಪೋಸಲ್ ಬೇಕೇನೋ? ಕೇಸ್ ಬೇಗನೆ ಮುಗಿಬೇಕಾ?
ಮುಗಿಬೇಕು ಅಂತ ನಾನು ಬಂದಿದ್ದು.
In this
ಏನಂತ
matter,
ಮಾಡಿದಾರೆ ಆರ್ಡರ್ ಕೊಡಿ.
no, may I submit, my lord? He had filed an application under section 50, IA number 15, that is under order 12 rule 6. And also IA under section 209 of IPC, read with the section 340 of CRPC, taking action against the council. He says that the council has made false affidavit or false written statement. That's the learned single judge has dismissed that petition on cost of rupees 10,000. Because he a frivolous
ಯಾಕಂದ್ರೆ
application.
ಆ 209 ಅಲ್ಲಿ ಬರುತ್ತೆ ಅದು. ಈಗ ಆರ್ನಬಲ್ ಹೈಕೋರ್ಟ್ 2-3 ಕೇಸ್ ಹೇಳಿದ್ದ ಯಾರಾದ್ರೂ ಅಡ್ವೊಕೇಟು ಯಾಕಂದ್ರೆ ಡಿರೋಗೇಟರಿ ವರ್ಡ್ಸ್ ಅನ್ನ ರೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಯೂಸ್ ಮಾಡಿದ್ರೆ ಈಸ್ ಪನಿಷಬಲ್ ಅಂತ ಈ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ಕೂಡ ಇದೆ.
ಏನು
ನನ್ನ
derogatory words, sir? Derogatory words ಏನು?
ಏನ್ ಸರ್
What are those derogatory words?
ವರ್ಡ್ಸ್ ಏನಂದ್ರೆ ಅವರು
ತೋರಿಸಿ.
ನಾನು ಇದಿಲ್ಲ ಇವತ್ತು ಪ್ರಿಪೇರ್ ಆಗಿ ಬಂದಿರ್ಲಿಲ್ಲ.
ಅದಕ್ಕೆ ಬಂದಿದ್ರಿ ಇಲ್ಲಿ?
ಅಲ್ಲಿ ನಾನು ಅಪ್ಲೈ ಮಾಡ್ಲಿಕ್ಕೆ ಬಂದಿದ್ದೆ.
ಅದಕ್ಕೊಂದ್ಸರಿ ಇದಕ್ಕೊಂದ್ಸರಿ ಡೇಟ್ ಕೊಡಕ್ ಬರಲ್ಲ. ಹೈಕೋರ್ಟ್ ಇದು.
ಅಲ್ಲ ಸರ್, ನಾನು ಚೆನ್ನಾಗಿಲ್ಲ ನನಗೆ. ನನಗೆ ಪೂರ್ತಿ ಚೆನ್ನಾಗಿಲ್ಲ.
You are not well.
ಎಲ್ ಸರ್. I have been suffering from stroke.
Okay.
Today I am speaking.
All right,
clearly.
ಅದ್ ಹೇಳಿದ್ರೆ ಟೈಮ್ ಕೊಟ್ಬಿಡ್ತೇವೆ.
ಅಲ್ಲ ಯಾಕಂದ್ರೆ ಇವತ್ತು
ಯಾಕಂದ್ರೆ?
ಚೆನ್ನಾಗಿ ಮಾತಾಡ್ತಿದ್ದೀನಿ.
ಟೈಮ್ ಕೊಡ್ತಾ ಇದ್ದೇನೆ, ನೀವು ಕೇಳಿದ್ದಕ್ಕೆ ಬೇಡವಾ?
ಅಲ್ಲ ಮಾಡಿ ಸರ್.
ಮತ್ತೆ
Time ಕೊಡಿ.
ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರೆ ಮತ್ತೆ ಆರ್ಗ್ಯೂ ಮಾಡೋದು. But which date you want?
29th January.
All this matter on 29th January at the request of 14% ತಾನೇ?
ಇಲ್ಲ ಸರ್.
ಅಲ್ಲ,
Counsel on
for
record.
appellate, sir.
husband of that petitioner.
ಯಾಕೆ ಆಗ್ಬಾರ್ದ ಹಸ್ಬೆಂಡ್?
ಆಗ್ಬಾರ್ದು ಹೇಳಿಲ್ಲ.
ಯಾಕೆ ಆಗ್ಬಾರ್ದು?
You want matter to be dismissed now?
No sir.
Why are you arguing like that with him? Are you not the husband of the party? That he is saying. Why are you saying all that?
Okay.
You should be like friendly with your friends, na?
Even when I asked for
They
copy,
are-
my lord,
No.
he said that give me your license, registration number, everything.
Yes.
I asked him copy. For that, he asked me give me license number, copy, give me the copy. For
Given or not now? Has he given it or not now?
Not yet, my lord.
What sir?
Will you give copy or not now?
I have received
I
only
give the
appeal memo copy.
Notice has been sent to all.
Sent again, we are telling you, give copy to him, pass over the matter.
Only appeal memo copy.
Those copies are them only.
Give one more.
Huh?
Give
I'll
one
send by
more.
post, sir.
Yes, call this, pass over.
ಸರ್ ಇಲ್ಲ ಇವತ್ತು ಆಗಲ್ಲ. ನಾನು
ಕಾಪಿ ಕೊಡ್ಲಿಕ್ಕೆ ಆಗಲ್ವಾ?
ಅಲ್ಲ ನಾನು ಚಿತ್ರದುರ್ಗಕ್ಕೆ ಹೋಗ್ಬೇಕು.
ಅಲ್ಲಿ ಇಂಗ್ಲೆಂಡಿಗೆ ಹೋಗ್ಕೊಳ್ರಿ ನೀವು, ನಾವೇ ಮಾಡ್ತೊಂಡು.
ಇಲ್ಲ.
The copy of the
ಕಾಪಿ
appeal paper,
ಸರ್ ಅದು ಏನಂದ್ರೆ
copy of the
ಸರ್ one thing.
appeal papers
ಹೇಳಿ.
to be furnished.
Sir.
ಕೊಡಲ್ಲ, ಕೂತ್ಕೊಳ್ಳಿ. Sit down. You cannot order the court. Court can order, not you. Sit down.
The notice has been sent to only an IA, sir.
Brother, we are
Notice is sent by only an IA, not on the main petition.
we are telling you, are you going to give copy or we should dismiss it on that ground?
I will send by post, I told sir.
No,
Because
you should give it now.
because-
Appellant to give full set of, you don't want to give the papers to your friend also.
So
What
only
is this happening
sir,
to the court?
annexures not given, that's all sir.
ನೋಡಿ, ಸುಳ್ಳೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಡಿಸ್ಮಿಸ್ ಮಾಡಕ್ ಆಗ್ತದೆ.
ಇಲ್ಲ ನಾನು ನಿಜಾನೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
ಮಾಡಿ.
ಯಾಕಂದ್ರೆ ನಾನು ಪ್ಲೀಡಿಂಗ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀನಿ.
Appellant is unnecessarily wasting the time of counsel for the appellant is unnecessarily making the submissions. When we are telling him to serve copy of the appeal memo along with all
Right.
documents on the learned counsel appearing for the respondent.
I'm
First,
saying
this is ununderstandable. First off, the appeal memo along with all the papers should reach the hands of the counsel for a respondent before the sunset of the day and acknowledgement to be filed in the registry illi before the sunset of the day, failing which appeal stands rejected. Yes,
ಸರ್
IA stands rejected.
ಸರ್ ದಯವಿಟ್ಟು ಸ್ವಲ್ಪ ಟೈಮ್ ಕೊಡಿ, ನನಗೆ ಚೆನ್ನಾಗಿಲ್ಲ.
ಕಾಪಿ ಕೊಡ್ಲಿಕ್ಕೆ
ಅಲ್ಲ ನನಗೆ ಕೆಳಗೆ ಹೋಗ್ಲಿಕ್ಕೆ ವಾಕ್ ಡೌನ್ ಮಾಡ್ಲಿಕ್ಕೂ ಆಗ್ತಾ ಇಲ್ಲ.
ನೀವೇ ಹೋಗಿ ಇಸ್ಕೊಳ್ರಿ, ಕೊಡಿ, ನೀವು ಇಲ್ಲಿ ಕುತ್ಕೊಳ್ಳಿ, ನಿಮ್ ಪೇಪರ್ಸ್ ಕೊಡಿ, ಅವ್ರು ತಗೊಂಡ್ ಮಾಡ್ಕೊಂಡ್ ಬರ್ತಾರೆ.
He'll make
ಕುತ್ಕೊಳ್ಳಿ, ನೀವು ಇಲ್ಲಿ ಕುತ್ಕೊಳ್ಳಿ, ಅವರೇ ಮಾಡ್ಕೊಂಡ್ ಬರ್ತಾರೆ, ಕುತ್ಕೊಳ್ಳಿ, ಕೋರ್ಟ್ನೆ ಕುತ್ಕೊಳ್ಳಿ.
ಇಲ್ಲ ನಾನು ಹೊರಗೆ ಹೋಗಿ ಇರ್ತೀನಿ.
ಹೋಗಿ ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಡಿ. ನೀವು ಹೊರಗಾರ ಹೋಗ್ರಿ, ಅತ್ಲಾಗಾರ ಹೋಗ್ರಿ, ನಾವೇ ಮಾಡಿ ನಿಮ್ಗೆ ಇಟ್ಕೊಂಡು ಅಷ್ಟು ವ್ಯಾಲ್ಯೂಯಬಲ್ ಅಲ್ಲ ನಮ್ಗೆಲ್ಲರೂ. ಎಸ್, ನೆಕ್ಸ್ಟ್.
I appear for petition in this case, my lord.
Yes, sir.
The petition is a government of Karnataka undertaking carrying
Yes.
on business in various products and services, my lord, including chit fund business. This writ petition is filed in pursuance of the order dated 23/9/2024, passed by the Honorable Apex Court in SLP number 34201 of 2024, my lord. The brief facts of the case are the petitioner has challenged the annexure J, my lord, which is annexure J, E and B, my lord. Annexure J is the order passed by the National Consumer Disputes Redressal Commission dated 9/7/2024. Annexure E is the order dated 11/2/2019, passed in appeal number 236/2017 by the Karnataka State Consumer Disputes Redressal Commission, my lord. And the order dated
Where are you?
Pardon me,
Where are you? Where are you? Why can't you come to the court?
I will
You don't want to come to the court?
ನನಗೆ ಈಗ ಚಿಕನ್ ಗುನ್ನೆ ಆಗ್ಬಿಟ್ಟು ಸ್ವಾಮಿನ ಅದು 15 ದಿವಸ ಮಣಿಪಾಲ್ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ಟ್ರೀಟ್ಮೆಂಟ್ ತಗೊಂಡೆ, ಇನ್ನ 2 weeks
Okay.
ಟ್ರೀಟ್ಮೆಂಟ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ. Therefore I am arguing from the
Issue emergent
consequent-
notice.
and the
Interim
annexure
order.
D may kindly be stayed, my lord.
All right, I have seen now. Yes.
Annexure D may kindly be stayed, my lord. This is the very base order passed by the District Consumer Commission, Mysore, my lord.
Interim order issue emergent notice, interim order as prayed for till next date of hearing.
Much obliged, my lord. Much obliged.
ಯಾಕೆ ಏನಾಗಿತ್ತು ಹೆಲ್ತ್?
ಚಿಕನ್ ಗುನ್ನೆ ಆಗಿತ್ತು ಸ್ವಾಮಿ. ಒಂದು ವಾರ ಮಣಿಪಾಲ್ ಇದ್ದೆ, ಈಗ ಬಂದಿದ್ದೀನಿ. ಮತ್ತೆ ಇನ್ನ 2 weeks ಟ್ರೀಟ್ಮೆಂಟ್ ತಗೊಳಕ್ಕೆ ಹೇಳಿದ್ರು ಸ್ವಾಮಿ.
Next.
Please, my lord. Much obliged, my lord.
Lordship, review petition in case of engineering analysis is pending before Honorable Supreme Court, my lord.
Pending.
Maybe urgent for 4 weeks, my lord.
Review,
Call after 4 weeks at the request of panel counsel appearing for the appellant on the ground that similar question is being debated before the apex court. Review petition.
Review petition.
On the ground that connected review petition is pending before the apex court.
It is, identical issue is also there in serial number 27.
ಇದು 24 ಜೊತೆ ಕಾಲ್ ಮಾಡ್ಬೇಕಾ?
ಅಲ್ಲ, ಜೊತೆ ಕ್ಲಬ್ ಮಾಡಿ.
24 ಬೇರೆ ಸ್ವಾಮಿ.
26,
26, 27
ಬೇರೆ ಅದು.
26, 27.
ಬೇರೆ ಇದೆ ಅಂತಲ್ಲ.
My lords,
Yes.
my lords, may I make a submission? As far as serial number 24 is concerned, it has nothing whatsoever to do with engineering analysis. It is a case of secondment.
Lordship, this matter is already
therefore,
adjourned,
even
my lord. Already adjourned with another writ appeal matter where the senior
ಆಗಿದೆ.
counsel appeared.
Call along with 15. Okay. After 4 weeks. Next.
My lords, may I request for a specific date? That's all.
Let us see. Yes, next.
Your Lordship, he is not in station. It may be kindly adjourned for a week, my lord.
2 weeks at the request of panel counsel.
29th and 30 are also review petitions
Pending.
pending, my lord.
Lord, review petitions are stated to be pending before the apex court. First, call after 6 weeks.
Yes, my lord.
6 weeks.
And another one matter, serial number 38 is also the same, my lord.
38,
38.
29, 30, ಎರಡು same
29, 30.
28 is
29, 30, 38.
28 Sushalti Varid, ಅದು different matter, my lord. ಅದರಲ್ಲಿ ಬರುತ್ತೆ.
ಅದು ಬೇರೆ, ಅದು 2 weeks ಅಂತ ಕೊಟ್ಟಿದ್ದು. 28.
2 weeks ಆಗಿದೆ.
ಅದಾಯ್ತು.
29 and 30 review petitions, my lord.
29, 30, 38.
38.
ನೋಡಿ.
38, my lords, admit ಆಗಿಲ್ಲ actually. That should come up in admission.
Admission ಆಗಿಲ್ಲ.
Final hearing ಬಂದ್ಬಿಟ್ಟಿದೆ.
Further hearing ಯಾಕೆ ಬಂದದ್ದು ಅದು?
Final hearing ಅಲ್ಲಿ ಬಂದಿದೆ. It's come in final hearing.
Final
It's
hearing
It's
ಬಂದದ್ದಾ?
actually pending at admission.
It is pending admission. ಅಲ್ಲಿ post it for admission ಆಗಬೇಕು 38 ಅನ್ನ. ಕರೆಕ್ಟಾ?
Yes.
Yes, post it for admission after 2 weeks.
Yes, my lord.
Okay.
With respect to the penalty, my lord, sir, impose a limitation to impose penalty.
Correct.
A learned friend had argued.
Yes.
I just have, I had filed my written submissions already, my lord. He is also, I understand he's given his written submissions.
My lord, written submissions may not by my colleague Tiwari, may not Mr. Tiwari.
Buddy.
Fine.
Just two additional points in addition to that. The only point, my lords were hearing the question with respect, the primary contention was that the initial notice was issued by an income tax officer who is not empowered to pass the final penalty order. And therefore, that notice issued by him should be disregarded for the purpose of limitation. It is the subsequent notice by the officer authorized to pass penalty which should be reckoned for limitation.
Correct.
Now, on that point itself, the Honorable Supreme Court has answered. But since my learned friend is not there, I have no, I've given him a copy, but if he's not there, I can be taken up if he wants another day. 2 copies.
ಏನಿದೆ ಇಷ್ಟೇ ಇದೆ matter.
ಇಲ್ಲ, issue ಏನಂದ್ರೆ, if I understand, my lord, because I have got another identical matter.
That is for,
Issue is when the
ಅದೇ ಯಾವತ್ತು post ಆಗಿದೆ?
when the
that came up last week, your lordships had adjourned it by 2 weeks.
For this awaiting this.
Same, ಇಲ್ಲ, awaiting ಆತರ ಏನಿಲ್ಲ. I think that was an SSC's appeal.
ಇಷ್ಟೇ ಇದೆ, ನಾವು ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಮಾಡಿ. ಒಂದು ನಿಮಿಷ
please,
ಕೇಳ್ಕೊಳ್ಳಿ.
please.
ಅಲ್ಲಿ 2 officers ಬರ್ತಾರೆ. ಒಬ್ರು competent authority who can pass the order. Another, an officer who can make reference to the competent authority. Question is of limitation. For reckoning the limitation period, is it from the date the competent authority puts the steps forward, or from the date an officer, ITO, tells the competent authority to do certain things? Delhi High Court said It is from the date the steps are put forward by the competent authority. Matter went in SLP and dismissed. Understood? And there are some judgments which you have quoted where a contra view appears to have been taken.
Kerala.
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 Iverada judgment naduve we have to choose one judgment.
ಹೌದು.
ಅಷ್ಟೇ ಕೇಸ್. ಇದಕ್ಕೆ ಏನಾರ ಆಡ್ ಮಾಡ್ಲಿಕ್ಕಿದೆಯಾ?
ಏನಿಲ್ಲ.
ಏನು?
The issue, my lord, if my lord permits me, the act specifically provides or bestows jurisdiction on a particular authority.
Competent authority.
Competent authority to do certain acts. Here
Correct.
it is initiation of penalty and imposition of penalty,
Correct.
both by the competent authority.
ಎರಡು aspect
If-
ಇದೆ. Initiation of penalty and accomplishment of penalty proceedings within the time stipulated by Parliament.
Understand? Now, so far as the assessing authority here is concerned, who is an income tax authority,
ITO.
ITO, he has not been bestowed with the jurisdiction either to initiate or to complete. So any statement made by him or whether any observation made by him
Cannot be
with
recorded.
regard to applicability or imposition of penalty cannot be treated as initiation of proceedings by a competent authority.
Okay.
Any action initiated ab initio void if it is not initiated by the competent authority. It is an observation made by the ITO during the proceedings. Because if my lordship sees for the imposition of penalty under 271(1)(c), the words used are if the assessing authority is satisfied. That is missing here, 271(d), and specifically another authority is bestowed with jurisdiction.
So
Reading other penalty proceedings, for example, 271(1)(c), it says, if the assessing authority is satisfied, then concealment, inaccurate particulars anta barutte.
that is conspicuously absent here. Anta.
Absent here.
How that makes the difference ಅನ್ನೋದು ಒಂದು point. That's absent is here true. The blind man can
Because the
see.
assessing, any authority below the rank of that particular authority who has been bestowed with jurisdiction is not an authority. He has absolutely no authority. Any observation, it's void ab initio. And if he has recorded something, it's only a recorded or an observation, which has zero value so far as imposition of penalty or initiation of penalty.
Because he is not the competent.
He is not the
authority.
competent authority.
That's what Kerala said.
And any proceedings based on initiation of something by an authority who has no jurisdiction at all subsequent proceedings also are invalid. If section 1, initiation of 148 in a case itself is bad in law, final outcome of assessment also will be bad only.
That is not what the Supreme, with respect, that's not what the Supreme Court says with respect to the same issue. There, the officers were assistant commissioner and inspecting appellate commissioner. There were the designation nomenclature changed. Otherwise, the powers, everything are the same. Supreme Court says merely because, let me finish, please. Merely because the lower authority does not have the authority to pass the order, that does not mean that he does not have the power to initiate the proceedings. On very same findings are there of the Honorable Supreme Court on
There
this
is
issue.
power to initiate given to him.
That is-
Power to initiate is given to the competent authority.
No, madam, with respect, the power to initiate, in fact, the legislature is silent on that. All that is the section provides is that the power to impose, no officer below the rank of joint commissioner shall have the power to impose penalty.
Correct.
It
So-
does not say, does not have the power to commence proceed, does not have the
No,
power to
that-
initiate.
No,
Imposition,
there should be specification saying that you have power to initiate.
in the absence of a restriction also, the Honorable Supreme Court, Delhi High Court, Rajasthan High Court and Calcutta High Court have held that in the absence of any restriction on the power to initiate, how can,
Nobody can initiate.
because ultimately, Manoj, even my learned friend, other friend Sushal Tiwari had read out the section 274 the other day, which says that monetary limits are there for imposition of penalty. If, for instance, an unauthorized officer does not have the power to pass the order, what does he do? He may have passed the original assessment order. He will then refer the matter to the officer competent to pass the penalty. Now, does that mean that the reference made by him also should go? That cannot be the case, merely because I don't have the
That's
power.
what Delhi said.
That is what Delhi, that's what Calcutta High Court and Rajasthan High Court have held.
Kerala,
Kerala is the only one which is contrary, which was followed by a circular. Subsequent to that circular, not one order has been passed in the favor of revenue on this point. The second point also, apart from this issue, my lords, is that there is a time settled principle that where two views are possible, penal provisions
favorable
must,
to the assessee to be
penal
taken.
provisions, that is, there's a fine judgment of the Honorable Supreme Court followed thereafter. The fact that my learned friend and I are arguing, the fact that a circular itself was imposed, has been issued, shows that two views are possible. Thirdly, my lords, the fact that, in fact, when this amendment was made to the section to introduce limitation, because earlier there was no limitation provided, when they introduced it by way of the Amendment Act of 1987, the CBDT itself says that we want to reduce and ensure expeditious disposal of penalty proceedings. I place that also on record.
No, limitation is for accomplishing the penalty
Yes,
proceedings,
so
not
if
for
the-
initiation.
Yes, so if there is no time limit given for initiation, if in this case, what happened was the initiation, according to me, was in 2016. According to the department was 2017, 1 year later. Now, take for instance, and the order ultimately passed in 2018. Now, if there is no sanctity given to the initiation done by the income tax officer, then where would the limit end for initiation? If the legislature in its conscious wisdom has not
For 5 years, they can
It could
sleep
happen.
over and they can say there is no limitation for.
Yes, so as long as I initiate it sometime, doesn't matter when, but if I complete it within 6 months, according to them, that would end the matter.
That will defeat the very
That will
purpose
defeat
of the act. Anta.
Of the Amendment Act, that will defeat generally penal provision, as my lords correctly, it's like a sword of Damocles hanging over my head. It is an assessment year 1213, penalty order passed in 2018, and on merits, crucially, that was the other point which I didn't get a chance to read. Yes.
In other words, what you are saying is, when statute is silent as to who can initiate,
Yes.
arguably they say by competent authority it can be initiated. You say it can be initiated by others, although it can be, steps can be taken by the competent authority.
Yes.
What you say is, the object of prescribing limitation would be defeated if their argument is accepted, will be served if your argument submission is accepted. That way.
Precisely.
All right. Heard, reserved. Okay.
I've just made a brief note and enclosed. I've given a copy to my.
ಅಲ್ಲ, otherwise,
Exact facts of the case.
ಒಂದ್ ನಿಮಿಷ ಕೇಳಿ ನೀವು ಏನು ನಿಮ್ ಕಾಗ್ನಿಷನ್ಸ್ ಪ್ರಾಬ್ಲಮ್ ಇದೆ ನಿಮಗೆ. ನಾವು ಮಾತಾಡುವಾಗ ನೀವೇನೋ ಒಂದ್ ಹೇಳಿ ನಮ್ ಡಿರೈಲ್ ಮಾಡ್ಬಿಡ್ತೀರಿ. ಹಂಗ್ ಮಾಡ್ಬಾರ್ದು. ಸ್ವಲ್ಪ ಅಟೆಂಟಿವ್ ಆಗಿ ಅವಧಾನ ಬೇಕು. Anyway, see what he says is also a factor. ನೀವನ್ನೋದು, there is a limitation for accomplishing the penalty proceedings. And there is no limitation for initiation. So he will initiate after 10 years. For all 10 years, he right to sleep, have sound sleep will be disturbed. I'm just putting this across so that to have, if there is a limitation period for accomplishing the penalty proceedings, and obviously textually within what period it should be initiated is absent. Because of that, you want to say at any time it can be initiated, but once initiated, it should be accomplished in time. That would be very, very literal.
The question before my lordships in this case is purely a question of law.
Correct,
My lord, dealing with jurisdiction of an authority.
correct.
The question, my lord, which is posed to me now, my lord,
It's question of law only.
it is question of law, but my lord, it is totally independent of the question of law, my lord, before my lordships with regard to the issue of jurisdiction.
No,
So
that
same-
arises now. That question arises. Which is question
Consequently-
of law?
Yes,
Any question, summoned says in his jurisprudence, any question answer to which can be found by turning the pages of statute book is a question of law. This is what Salmon says. Salmon describes question of law, question of fact, question of discretion, question of opinion. All these four are discussed by him in a separate chapter. Now, the question raised before the court is, number one, if there is prescription of limitation period for accomplishing the penalty proceedings, can it be argued that that restriction is only post initiation, and for initiation there is no limitation, Even if when things were done, when Alexander had come here, now you can do that. But once you start, you have to do it within the period. That will be very, very militantly, it runs militantly counter to the policy on which the period of limitation is prescribed for accomplishment of the proceedings. Another your contention. That will defeat the very purpose of the act. One of the principles says we should interpret the provisions of law as not mutilating the parliamentary intent on which certain other provisions are structured. It appears that way. Though in that language you are not telling. This appears to be the pith and substance of your submission. But this aspect is not addressed either by Delhi or by Kerala. This reasoning, just jurisprudential reasoning,
yes, sir.
I did not find being treated or discussed by both these courts.
Kerala, Delhi, it is there in the latest judgment. May I just take 2 minutes from my lord?
Sorry. In Delhi, it is there.
Yes. ಹೌದು ಪೇಜ್ ನಂಬರ್ 34 ಇಲ್ಲ ಅದು ಅವ್ರದ್ದು ಅದು ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್ ಈ ತರ ಆಯ್ತು 69 page.
Delhi is that Turner General Entertainment, na?
Yes.
Read. Revenue has projected several questions for consideration. So and so. Which paragraph treats this reasoning?
Yes, I'll just take my notes. Page 37, para 15 onwards, ma'am.
Para 12.
Para 12. May I just read, ma'am? Mr. Sharma, the learned counsel appearing for the revenue.
Last 3 lines.
Yes.
And the initiation.
Please, ma'am. Mr. Sharma, although the delay in the case of PCIT versus JKD Capital was more than 5 years and there was no explanation to the said delay, the said decision also rests on the principle that the initiation of penalty proceedings cannot be delayed in an arbitrary manner. And the initiation of proceedings must be considered as on date in which a reference was made to the concerned officer, if not earlier. That is his argument. In the present case, the learned JCIT, after receipt of the reference of penalty proceedings, had not taken immediate steps for concluding the said proceedings. He issued the show cause notice almost a year after receiving the reference. The expression initiated is not defined under the Act and must be construed in its normal sense. The word initiated is a past tense of the word initiate. The shorter Oxford Dictionary
To begin, commence, etc.
To begin, so and so.
Webster's third use.
Please. It
Then
reads to begin or set going, make a beginning of, perform or facilitate.
Anyway, next
Yes.
point, we can go. There's only simple
Please.
English words. Yes.
Then even para 18 minutes is a judgment which considers the meaning of the word initiate. The para 19 minutes.
To initiate as meaning to commence.
Yes.
Next, come to 19.
The expression action for imposition of penalty is initiated, that is in 275(1)(c),
Clearly
must
refers
thus
to this.
clearly refer to the date on which the first introductory step for such action is taken. It must necessarily mean the start of such action. It must mean the commencement of action for imposition of penalty. As noted above, the AO had found that it was the admitted case that the SSC had defaulted in deduction of TDS, which it was obliged to do. It had accordingly made a reference to the learned JCIT. This was obviously for the purposes of imposition of penalty. The reference thus clearly marked the first step for initiation of action for imposition of penalty. The show cause notice issued subsequently was to provide the SSC an opportunity
Only
to
to
show
give an
cause.
opportunity to him.
Yes.
Not beyond that.
Not beyond that.
So once initiation happens, in other words, when the ITO says something,
Yes.
which is being acted upon by the competent authority to take steps and give opportunity,
Yes.
initiation happens.
That is what the Honorable Delhi High Court says. In my case also, the order imposing penalty makes a reference to the reference by the income tax officer. Yeah, I'll read. In the given context, this was in the beginning of the action for imposition of penalty. The same had commenced earlier with the AO determining that there was a cause for such imposition. In view of the above, we find no infirmity of the decision, so and so. And the order of penalty passed by the learned.
This went in SLP.
No, no, this was in fact.
This did not.
This did not. The earlier, I placed 4 earlier orders, all Delhi High Court. One of them was carried in SLP minutes. The one, other minutes, it starts at, Delhi High Court decision starts at page 20. Clicks capital. 20. My lords have it. Page 25 is where the relevant findings commencement.
25.
Yes.
Paragraph
16, my lords, in the middle.
You're right.
May I just read? We have heard the learned counsel for the parties. According to us, at the heart of the matter is the interpretation that is required to be given to the provisions contained in 275(1)(c) of the Act. For the sake of convenience, the provision is extracted here under. I'll just skip that, my lord. As would be evident, the aforementioned provision has 2 limbs. The first limb concerns fixation of period of limitation when penalty is sought to be imposed as a fallout of action taken in another proceeding. On the other hand, the second limb of clause C of subsection 1 of 275 of the Act fixes the period of limitation where initiation of action of imposition of penalty is taken on a standalone basis. That is not as a consequence of action taken in other proceeding. 17.1. For the second limb, the legislature has provided a limitation of 6 months from the end of the month in which action for imposition of penalty is initiated. It is apparent that while a time frame has been provided for the conclusion of penalty proceedings once initiated, there is no indication as to when the period of 6 months ought to commence. In other words, can initiation of penalty proceedings be left to the whims and fancies of the revenue, or it should be hitched to the dicta of reasonable period adopted by courts in such situations in the absence of a statutory provision? We may also note that it is common ground between the parties that what the court is called upon to construe is the second limb of C of section 275(1) of the Act. The counsel for the parties have taken diametrically opposite stands on this aspect of the matter. However, we are inclined to agree with the submission made on behalf of the petition, that is the SSC, and the reason for that is quite simple. If we were to accept the respondent revenue stand.
What inclined to accept submission? Where is that submission?
Yes, ma'am. The submission, my lords, will commence at.
Where is that articulated submission?
Please, my lords, may kindly see para 10 and para 13, my lords, page 24. I'm sorry, page 24, para 13. May I read, my lords?
(13.2).
Yes. Mr. Jolly further submits that once the respondent revenue had taken in principle a decision to initiate penalty proceedings, the issuance of the show cause notice as mandated under 274 of the Act could not have been delayed interminably, as was the approach adopted by the revenue in this case. The argument advanced is that there are several provisions in the Act where, although a limitation period is prescribed for completion of proceedings, nothing is stated as to when the proceedings would commence, that is, be considered as having been initiated. In this context, Mr. Jolly has drawn our attention to section 275(1)(c) of the Act. In particular, he has drawn our attention to the second limb of clause C of so-and-so. In support of his plea, the courts have read in the concept of reasonable period for commencing proceedings when there is no such indication given in the statute. Mr. So-and-so has relied upon the following judgments. I'll just read paragraph 14, my lords. Mr. Jolly also submits that if
He says that will be if if it is otherwise construed, that will defeat the period of prescription.
Yes, precisely.
Where they have done that 14.
Yes.
15.
Please. On the other hand, Mr. So-and-so, learned senior standing counsel who appears on behalf of the respondent revenue, submits that penalty proceedings initiated in the instant case were separate and distinct and not related to any other proceedings. It is therefore his submission that since the legislature has not provided a trigger point for completion of proceedings under 271(c), the date of commencement can only be that date when the show cause notice is issued under
The competent authority.
Please, precisely. Yes. In support of the plea that penalty proceedings contemplated in the second limb of 275(1)(c) are separate and distinct, reliance was placed on the judgments of this court in CIT versus IKEA and Subodh Kumar Bhargava, so-and-so. That, my learned friend, I pointed out that arises slightly. My lord, may I kindly go back to para 20, my lords, where the findings are.
The initial return for the assessment year in issue
Yes.
21.
Yes.
No, just we wanted to ascertain. Even Delhi court and Kerala,
Yes.
both they agree. There is no limitation for initiation. In that situation, what should happen?
Yes.
So one is doctrine of reasonableness. Because where no limitation is prescribed, then reasonableness is the rule.
Yes. Yes.
Correct?
Yes, precisely. Yes.
ಇದರಲ್ಲಿ ಎಷ್ಟು ದಿವಸ ಡಿಲೇ ಇದೆ? ITO ಯಾವತ್ತು ಹೇಳಿದ್ರು?
Yes.
ಇನಿಷಿಯೇಷನ್ ಯಾವತ್ತು ಮಾಡಿದ್ರು?
I'll just reiterate the dates, Manoj. I mentioned it.
ಒಂದೇ
but-
ನಿಮಿಷ.
Yes.
Yes, para 5 of your this one you had mentioned it.
I can mention it once. ITO's notice, my lord, 16/11.
16/11/2016.
Show cause notice,
This is 2017.
please, November 10/11/2017, almost
November
1 year.
2017.
An order passed in 2018.
That order is passed
yes.
within time.
Yes, within.
But again, it depends upon from which date
From
you
when.
are reckoning.
Yes, yes.
Okay.
It only turns on when was it initiated.
Correct. ಇವ್ರ ಪ್ರಕಾರ ಕಾಂಪಿಟೆಂಟ್ ಅಥಾರಿಟಿ ಶೋಕಾಸ್ ನೋಟಿಸ್ ಕೊಡ್ತಾರಲ್ಲ ಅವಾಗ
ಅವಾಗ
ಇನಿಷಿಯೇಟ್
initiate ಆಗಿದೆ.
ಅವ್ರು ಡೆಲ್ಲಿ ಅವ್ರು ಹೇಳೋದು ಶೋಕಾಸ್ ನೋಟಿಸ್ ಕೊಡೋದು ಅವನಿಗೆ ಒಂದು ಅಪರ್ಚುನಿಟಿ ಕೊಡ್ಲಿಕ್ಕೆ ಅಂತ. ಸೊ ಆಕ್ಚುಲಿ ಇಟ್ ಈಸ್ ಇನಿಷಿಯೇಟೆಡ್.
Yes.
ಅದನ್ನು ಸರಿಯಾಗಿ ಹೇಳಲ್ಲ ಅವ್ರು ಎರಡು ಇಬ್ರು. ದೇ ಗೋ ಆನ್ ಡಾಕ್ಟ್ರಿನ್ ಆಫ್ ರೀಸನೇಬಲ್ನೆಸ್ ನಾಗ ಹೊಂದ್ಕೊಂಡ್ಬಿಟ್ರು. ಯಾಕಂದ್ರೆ ಇನಿಷಿಯೇಷನ್ ಅಂತ ಬಂದ್ಬಿಟ್ರೆ ಅಲ್ಲಿ ಲಿಮಿಟೇಷನ್ ಇಲ್ಲ. ಸ್ವಲ್ಪ ಬಟ್ ನಿಮ್ಮ ವಾದ ಒಪ್ಪಿದ್ರೆ ಎನಿ ಟೈಮ್ ನಾವು ಮಾಡ್ಕೋಬಹುದು. ಅದು ಮಾಡಿದ ಇನಿಷಿಯೇಟ್ ಆದ್ಮೇಲೆ ಅದನ್ನ ಪರ್ಟಿಕ್ಯುಲರ್ ಪೀರಿಯಡ್ ವೆರಿ ಮಿಲಿಟೆಂಟ್ಲಿ ಅಗೇನ್ಸ್ಟ್ ದ ಪಾಲಿಸಿ ಆಫ್ ದಿ
Keeping apart that limitation, which will go
ಬಿಯಾಂಡ್
eternally. But whether a reference made by a lower authority to a authority higher in rank, who specifically,
initiation or not.
whether, my lord, he is bound by that reference, or there is another thing. ITO might have just made a statement or recorded that.
The competent authority is not bound by that.
Not bound. So that would amount to reading the statute to say that the reference made by a lower authority, I mean, the authority who is bestowed jurisdiction is bound by the reference. It could be read like that in some other cases tomorrow.
But if he chooses to take action based on my reference,
Because
that's admitted in
there
my
is one
case.
difference.
Once you choose that, then this
Then-
thing will not arise.
My learned senior is correct.
One small submission, my lord. Reference is between two authorities, internal communication. But initiation is specifically against the person who will be affected or who is required to answer
Assessing.
assessing and by the competent authority. Still,
ಅಲ್ಲ ನೀವು ಶೋಕಾಸ್ ನೋಟಿಸ್ ಕೊಡೋದು
ಹಾ.
ಏನಂತ ಕೊಡ್ತೀರಿ? ಇನಿಷಿಯೇಟ್ ಯಾಕೆ ಮಾಡಬಾರ್ದು ಅಂತ ಕೊಡ್ತೀರಾ?
initiate,
ನಿಮ್ ಪ್ರಕಾರ ಅವಾಗೂ ಇನಿಷಿಯೇಟ್ ಆಗಲ್ಲ.
initiate. Why penalty should not be imposed for having violated section so and so, so and so. Normally, it will be in that format.
ಹೆಂಗಿರ್ತದೆ ಫಾರ್ಮ್ಯಾಟ್ ಇದೆ ಏನದಕ್ಕೆ? How the text of notice. Why penalty proceeding should not be initiated against you ಅಂತ ಇರ್ತದೋ,
ಹಂಗೆ
why penalty should not be levied on you ಅಂತ ಇರ್ತದೋ, ಯಾವ ರೀತಿ ಇದೆ ಅದು?
I've got a copy, Manoj.
ಫಾರ್ಮ್ಯಾಟ್ ಇದೆಯಾ?
It is, I'll just read out, I have copies
But
of it.
we'll have specific.
Is there format?
It may not be prescribed format, but generally
That will
there's like
be
a
that-
template which is there.
ಹೆಂಗಿದೆ ಅದು?
Whereas during the course of assessment proceedings, so and so, it was seen. so and so.
ಯಾಕಂದ್ರೆ ವೈ ಐ ಆಮ್ ಆಸ್ಕಿಂಗ್ ದಿಸ್
Yes.
ಕ್ವಶನ್ ಈ ರೀಅಸೆಸ್ಮೆಂಟ್ ಗೆ ವೈ ಅಸೆಸ್ಮೆಂಟ್ ಶುಡ್ ನಾಟ್ ಬಿ ರೀಓಪನ್ಡ್ ಅಂತ ನೋಟಿಸ್ ಕೊಡ್ತೀರಿ,
Please, please.
ಕರೆಕ್ಟಾ? ದಟ್ಸ್ ದಿ ಪ್ರಾವಿಷನ್
That is, yes. How?
ಅಲ್ಲಿ. ಇದರಲ್ಲಿ ಆ ರೀತಿ ಇಲ್ಲ.
It merely says, my lords, in this regard, you are hereby requested to appear at my, this is by the the competent authority to pass the order. In this regard, you are hereby requested to appear at my office at the above mentioned address at so-and-so date and show cause why an order imposing penalty should not be made under.
So not initiation,
No.
the levy itself.
Yes, why an order should not be made imposing penalty under 271D. If you do not wish to avail this opportunity of being heard in person or through an authorized representative, you may show cause in writing or before the said date, which will be considered before any such order is made under section 271D of the Act.
Copy there, no?
I have copies, yes.
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 Copies. Good.
And then this aspect with respect to competent officer to pass the order, but is he still competent to initiate proceedings? That the Honorable Supreme Court has also answered, my lords.
It is answered.
Yes, yes.
With the apex court.
Apex Court, not by the officers, then the designation nomenclature was different. I've just given a copy.
ಏನಂತ ಆನ್ಸರ್ ಮಾಡಿದಾರ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆಯಾ?
I have given it, man. Today's submissions.
ಅಲ್ಲ ಒಂದು ಆಸ್ಪೆಕ್ಟ್ ಇದೆ.
Yes.
ದಿ ಇನಿಷಿಯೇಷನ್ ಯಾವಾಗ ಮಾಡಬೇಕು ಅನ್ಕೊಂಡು ಪಾರ್ಲಿಮೆಂಟ್ ಹೇಳಿಲ್ಲ.
ಇಲ್ಲ. Yes.
ಕರೆಕ್ಟಾ?
Please, no.
ಇನಿಷಿಯೇಷನ್ ಅಂದ್ರೆ ಏನು ಅಂತಾನೂ ಹೇಳಿಲ್ಲ. ಕರೆಕ್ಟಾ?
Yes.
ಪೆನಾಲ್ಟಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ವಿದಿನ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಪೀರಿಯಡ್ ಮುಗಿಬೇಕು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. It presupposes initiation. But what is meant by initiation is not said.
No.
Number
Yes.
one.
Yes.
Number two, where the object of a provision which prescribes limitation to accomplish a particular exercise is in favor of the citizens, assessees, then whether even when textually no period is prescribed for initiation as such, whether court can read some limitation on that is the question. ಹಂಗ್ ಫ್ರೇಮ್ ಮಾಡ್ಬೋದಾ?
Yes, ma'am. Yes. Please.
ಆ ರೀತಿ ಮಾಡಿದಾಗ ಅಲ್ಲಿ ಲಿಮಿಟೇಷನ್ ಅಂತ ಬರಲ್ಲ, ಡಿಲೇ ಅಂಡ್
Delay,
ಲ್ಯಾಚಸ್
latches.
53, 54 ಅಂತ ಗೌರಮ್ಮ ವರ್ಸಸ್ ಸ್ಟೇಟ್ ತೆಗಿ ಧಾರವಾಡ ಬೆಂಚ್. ವಾಟ್ ಈಸ್ ಲಿಮಿಟೇಷನ್, ವಾಟ್ ಈಸ್ ಲ್ಯಾಚಸ್ ಟ್ರೀಟ್ ಮಾಡೇವಲ್ಲ ನಾವು. PTCL ನಾಗಿದೆ ನೋಡು. ನಾವೇನು ಬ್ರಾಡ್ಲಿ ಹೋಲ್ಡ್ ಮಾಡೇವಿ ಅಂದ್ರೆ ಆಫ್ಟರ್ ಸೀಯಿಂಗ್ ಜಸ್ಟಿಸ್ ಹಿದಾಯತುಲ್ಲಾಹ್ ಜಡ್ಜ್ಮೆಂಟ್, limitation is a matter for the legislature to prescribe. Delay and latches, it's a matter relating to the domain of the court ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದೀವಿ ನಾವು. ಫಸ್ಟ್ ಪಾರ್ಟಿಗೆ limitation ಅನ್ಲಿಕ್ಕೆ ಬರಲ್ಲ, as you rightly said, because no limitation is prescribed for initiation. Then it fits into the concept of delay and latches. Even the Delhi High Court Shakhtar judgment also, though not, it is said actually, ಅಲ್ಲಿ ಡಿಲೇ ಅಂಡ್ ಲ್ಯಾಚಸ್ ಅನ್ನೋ ಅರ್ಥದಲ್ಲಿ ಏನೋ ಒಂದೆರಡು ಪ್ಯಾರಾಗ್ರಾಫ್ ಇದಾವ. ಅದರಲ್ಲಿ ಡಿಲೇ ಎಷ್ಟಿದೆ ಇನಿಷಿಯೇಷನ್ ನಿಮ್ಮದ್ರಲ್ಲಿ?
In the present case, ma'am.
Huh?
In the present case, ma'am.
Ah.
Between the ITO issuing the notice and the competent authority issuing the
Issuing
subsequent
the notice.
is
ITO issuing notice ಅಲ್ಲ,
ITO
ITO
making the
asking the
reference. Yes,
competent
I'm sorry.
authority to
Yes.
initiate ಅನ್ನೋ ಅರ್ಥದಲ್ಲಿ.
It is 6 days short of 1 year, 16/11/16 to 10/11/17. So 359 days.
359 days.
Please.
ಇದು ಕಂಪ್ಲೀಟ್ ಆಗ್ಬೇಕು ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅನ್ನೋದು ಎಷ್ಟಾಗ್ತದೆ ಪೀರಿಯಡ್?
6 months.
6 months.
6 months from.
One view nil 6 months. But there is another aspect where
is-
order is passed from that date, it is 1 year.
Yes, yes, that is, but that would not apply in our case.
That will not apply.
That would not.
Even ಆ ರೀತಿ ತಗೊಂಡ್ರು there will be delay of
Sorry.
even then.
Yes, ma'am.
If that is taken also, then if this is taken, there is delay of 359 days.
Yes.
Suppose from the date the initiation, the shokad notice ಕೊಟ್ಟಾಗ ತೊಗೊಂಡಿದ್ರೆ ಯಾವಾಗ ಬರ್ತದೆ?
It is in time. The order was passed.
ಅವಾಗ in time ಆಗಿಬಿಡ್ತದೆ.
Please, ma'am. 6 months from the end of November 1700, by 31st May 2018, he had to pass it. He has done so in time.
ಆ ಇನಿಷಿಯೇಷನ್ ಇಂದ ತಗೊಂಡ್ರೆ
Please, ma'am.
ವಾಟ್ ಈಸ್ ಇನಿಷಿಯೇಷನ್ ಅಂತ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಅವ್ರು ಕೊಟ್ಟಾಗ ಇನಿಷಿಯೇಷನ್ ಆಗತ್ತೆ ಅನ್ನೋ ಇವಿವನ್ ಅಡಾಪ್ಟ್ ಮಾಡಿದ್ರೆ ಈ ರೀತಿ ಆಗ್ತದೆ.
Please.
ಆಲ್ ರೈಟ್.
If my
ಈಗ ವಿಲ್ ಅಸ್ಯೂಮ್ ದಟ್ the initiation is, we'll assume now. Initiation is from the date when show cause notice is issued. What is the explanation for the delay? Other explanation is, we'll assume that now. That initiation is from the date the competent authority initiate the proceedings by issues the show cause notice. What is the explanation for the delay brooked between the recommendation by the ITO and issuance of show cause notice to the assessee? Adest period ide.
He's silent on that. In the show cause notice which I've given, he doesn't.
ಏನು ಹೇಳಿಲ್ಲ. He assumed that when I issue notice from that date in proceedings ಅನ್ನೋ show cause notice ನಲ್ಲಿ ಏನು ಹೇಳಿಲ್ವಾ? ಅಲ್ಲಿ ಒಂದು ನಿಮಿಷ. Both sides appreciably agree that the statute prescribes particular period of limitation for accomplishing the penalty proceedings, and that nothing is stated about when the penalty proceeding to be initiated or when they are said to have been initiated. First, revenue argues that limitation is only for accomplishing the penalty proceedings, and therefore court cannot read any limitation period while initiating the penalty proceedings. First, contra is the submission of counsel appearing for the assessee on the premise that the court should construe provisions of the kind as not to defeat the legislative intent. And if that is done, the initiation should be presumed to have been done when the ITO sends, recommends to the competent authority to step forward. First, this is the only point. One second. In the notice issued by the competent authority on 10/11/2017, the delay and lapses that would arguably would figure in initiating the penalty proceedings is not spoken of, the said delay being 359 days, should initiation be construed as having taken place when the ITO had sent the intimation to the competent authority. All right. Result.
Just one
May
sentence
I
in
draw my lordship's attention to page number 15
of
the appeal, where my lord, the order of assessment is
appeal
annexed. Appeal.
Not section 71D, this 1C and the yellow.
And that's why, my lords, the order of assessment specifically at the end of the order of assessment, it speaks about issue notice for penalty under 271(1)(c). So normally, ITO, so far as 271(1)(c), he says I'm issuing.
But that is not the penalty imposed.
That
Penalty
is not
imposed
penalty
is 271D.
That's why I'm making a difference.
Initiate ಅನ್ನೋ ಅರ್ಥದಲ್ಲಿ ಹೇಳಿ.
Initiate
But that is a different
where
section.
is empowered to initiate.
section.
It's a altogether different penalty,
It
271.
is altogether different. That's why I'll come to that.
ಇದಕ್ಕೆ ಸಂಬಂಧಪಡಲ್ಲ ಅದು.
Not at all.
ಇದಕ್ಕೆ ಸಂಬಂಧ ಪಡಲ್ಲ. But ಯಾಕೆ ನಾನಿದೆ, my lord, reason for making this submission is wherever the assessing authority is empowered to issue a notice, he will record it, his satisfaction for issuance of notice in the order of assessment itself.
Issuing of notice is one thing. Initiation
That will be
is
taken as initiation.
when it takes place ಅನ್ನೋದು argument ಈಗ.
Page number 15 ನಲ್ಲಿ, wherever is bestowed with jurisdiction, he will record it in the order of assessment itself. Page number 15 ನಲ್ಲಿ ಇದೆ ಅದು.
There's no argument on that. The question is when since he is not competent to pass the penalty order on altogether.
Wherever he is
different
competent, he will record it in the order of assessment itself.
Issue demand notice and challan accordingly. Penalty proceedings under 220 of the IT Act 97 initiated separately. ಇದನ್ನ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಆಫೀಸರ್ ಹೇಳ್ತಾನೆ.
different
Whereas
penalty.
he is bestowed with the jurisdiction. Here, he is only making a reference.
ಇನ್ ಆಲ್ ಕೇಸ್ ನಲ್ಲಿ ITO ಹೇಳಿದ ಮೇಲೆ ಮಾಡ್ತೀರಿ ನೀವು? ಜಸ್ಟ್ we want to know. ನಿಮ್ಮ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಎಲ್ಲ ಮಾಡ್ತಿರಲ್ಲ, when you issue notice, you do it only after getting the information or recommendation from the ITO or otherwise also?
A reference in there, because what happens is it's all together with the for case files, records are with some other officer. No, and
I am asking.
the jurisdictional authority who has
You are
got
not
the
answering. You are going elsewhere.
No, he will not have the knowledge that such a violation.
It's ನಮ್ಮ ಕ್ವಶನ್ ಏನಿದೆ ಹೇಳಿ. ನಮ್ಮ ಕ್ವಶನ್ ಸಿಂಪಲ್ ಇದೆ. ಈ ಶೋಕಾಸ್ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡ್ತಿರಲ್ಲ, ವೈ ಪೆನಾಲ್ಟಿ ಶುಡ್ ನಾಟ್ ಬಿ ಲೆವಿಡ್ ಅಂತ, ಅದನ್ನ ಇಂಡಿಪೆಂಡೆಂಟ್ಲಿ ಆಫ್ ದ ರೆಕಮೆಂಡೇಶನ್ ಆಫ್ ದ ITO ಮಾಡ್ತೀರೋ ಅಥವಾ ITO ದಿಂದ ಇನ್ಫಾರ್ಮೇಶನ್ ಬಂದ್ಮೇಲೆನೆ ಮಾಡ್ತೀರಾ?
Normally, it will be only after receiving it from the ITO.
Information only.
If it comes to him, comes to his knowledge, even otherwise, he has the powers to initiate separately.
Are there any one single incident ಇದೆಯಾ ಆ ರೀತಿ ಮಾಡಿದ್ದು? ಅಸರ್ಟನ್ ಮಾಡ್ಬೇಕು.
The act does not prohibit the authority who is bestowed with the jurisdiction to proceed with the
even without recommendation.
Yes.
That's all right. That goes without saying. But ನೀವು ಇನಿಷಿಯೇಟ್ ಮಾಡೋದಿದ್ರೆ ಇವನ್ ರೆಕಮೆಂಡೇಶನ್ ಮೇಲೆ ಮಾಡ್ತೀರಿ, ಅದರ್ವೈಸ್ ಯು ಹ್ಯಾವ್ ನೋ ಅಪರ್ಚುನಿಟಿ.
reference. I would rather call it
Reference.
Reference. I will
Correct.
not say recommendation.
Correct.
Reference.
Reference.
Because he will not have the power to recommend.
ಇಲ್ಲ, ರೆಫರ್ ಮಾಡ್ಲಿಕ್ಕೆ ಪ್ರಶ್ನೆ ಅಲ್ಲ. ಅವ ರೆಫರೆನ್ಸ್
He will forward the records. I will put it in a
ಇನ್ಫಾರ್ಮೇಶನ್ ಕನ್ವೇಯಿಂಗ್ ಅಷ್ಟೇ ಅದು.
He will just forward the.
ಅವನ
information.
ಇನ್ಕ್ಲಿನೇಷನ್.
There is a violation. Please look into it.
And in the penalty order, which is past minutes, in fact, the second para, he starts with saying, on receipt of reference from the assessing officer, a notice under 271D was issued on 10/11/17. So he admits that I got the reference from the ITO. I then
Invariably,
I'm sorry.
invariably,
Yes.
it can happen only after a reference from the ITO.
Yes.
Otherwise, he will not be knowing
Have
it.
knowledge, yes, yes.
ಯಾವುದು ಏನು ಗೊತ್ತಾಗೋದೇ ಅವಾಗ.
Yes.
ಹಂಗಾಗಿ independently he may have power. Existence of power is one thing. Its exercise is another. For exercising, certain foundational facts are necessary. Those foundational facts are furnished by the ITO. ITO says, ಈ ರೀತಿ ಆಗಿದೆ, so I recommend that, and whatever language he may use. He triggers the proceedings, is your argument. So that is initiation.
That is when action is taken for the first time. And 6 months is the limitation from when action is first taken.
In a given scenario, my lord, my humble submission would be, nothing prevents the joint commissioner from seeking information of violation of 269 SS from all the lower authorities. Please inform me, or give me the details of SSCs who have. It happens normally between.
Intra-departmental.
It need not be exclusively or purely on the reference of the AO. A reference of the AO could also have been made because of a letter or a communication.
No. It has to be on the reference of this
It
ATO
has.
only.
That reference also, on a particular day, maybe the joint commissioner will write to all the
But
lower authorities.
He may say, give us the information.
Good, I'm just.
Then they will give. Sending information on requisition is one thing. He himself sending suo motu the information is another. Either way, the information has to come from the office of the ITO. Correct? Either way, whether this or that, the information has to emanate, the epicenter is the office of the ITO, not anybody else.
Because he is the original authority.
He will have everything.
He
The
has
documents are
detected
with
the
him,
violation.
information is with him, that way.
Interesting question.
Very interesting question. Very interesting, both you have made it. ಎಷ್ಟು ವರ್ಷದಿಂದ ಇದೆ ಈ ಸೆಕ್ಷನ್?
It's 275, 1987 Amendment Act, so about
87.
35 years, not.
35 years.
Yes.
Mr. Palkiwala has not said, Kanga Palkiwala has not said anything about that.
Not about this one.
He has not said. Did you check that?
I verified, I have checked. Because initially, there, as I was mentioning, that act did not provide for a limitation.
Pithasariya ankonde
Yes, sir. That is also.
another book.
Yes.
Pithasariya.
It's a, it's a,
Pithasariya. Even that does not say.
That I'll verify that.
There is another Iyengar.
Yes.
Iyengar is
Sampath
also.
Iyengar.
Sampath Iyengar. They fought a defamation
Yeah,
case,
please.
a
Copyright
copyright
suit
violation
was-
case in
yes.
Madras High Court,
Please, miss.
where Shirvai appeared for Palkiwala.
Please. Came to be cross-examined also and.
And Palkiwala himself cross-examined that person.
Trying.
And the court was convinced that Palkiwala has not copied, but Iyengar himself has copied his books. Madras High Court, very old case, very interesting case.
Palkiwala, the majority of the work input was given by his brother.
B.A. Palkiwala. Palkiwala's books were referred even when they were not printed. Manuscripts are referred by the judges. In English law, unless the writer is dead, he is not taken as an authority. In one case, an English lawyer was arguing. Judge said, the author you are mentioning is still alive. Therefore, he is not an authority. The lawyer joked, wait, please wait, kindly have it, adjourn it by 1 week, I will get him shot dead. So that he becomes the authority. But in the Indian context, we are not doing that. In India, we do not seek the death of the author. Because when Shirvai was sitting in the open court, Shirvai's writings were referred by the apex court. That's how it was. Very well. Heard reserved. ಇದಿಷ್ಟ್ರ ಮೇಲೆ ಸ್ವಲ್ಪ ಯಾವ್ದಾದ್ರು books authors ಏನಾದ್ರು mention ಮಾಡಿದ್ರೆ
Please, please.
just give it.
Please.
Let us see.
I'll furnish it.
Okay. All right. Next. Thank you. Thank you. So beautifully both you have argued. Other day, your friend also argued very well. Very well.
He's appearing before Dharwad bench.
Dharwad bench. All right. Call after 2 weeks, huh?
2 weeks.
Okay. Next. Is it 35 password ಮಾಡಿದ್ವಿ ನಾವು?
Well, it's 34 I am appearing. I am for the
34.
respondent.
Yes, Mr. Rao, your friend is in Dharwad.
Very
We
well,
will
my
give
lord.
him one adjournment.
Very well, my lord.
Done. All right.
So it will come up after 2 weeks, my lord.
Time to. Mr. Naganand is waiting. Whichever date you want, we'll give you.
Any date convenient to the court, my lords.
2 weeks.
Obliged to my lords.
All right, 2 weeks. Mr. Naganand is waiting for this OSA. Not OSA, okay. That is somebody has taken time. What?
Illa.
Yes.
You know, 36, my lord, we were asked to get the case records and the date was given last Monday, my lord. So if a specific date is given, we have to get the case records of the search records rather.
All
A date may be fixed. We'll
All
have the
right. Call
officer-
this matter which date?
Any,
ಯಾವ್ದನ್ನೊಂದು ಹೇಳಿ.
next week, my lord, any day. ಯಾವ ದಿನ?
Next week, probably week after next.
Okay, week after next.
Week.
Week after next.
Yes, okay.
Please.
One date ಕೊಡಿ. Call this matter on 29th to comply with the order dated 18/7/23. Okay.
It will-
Yes. Yes, sir.
500 days delay, my lord, no explanation. No explanation whatsoever. Lordship may see that.
350 days ಅಂತ ಏನಿದೆ.
2 years.
350 days. Delay.
350 days.
350 days.
But that may not be correct, my lord.
Is it?
I got the dates. The copy application, my lord, was received on 12/3/21. The petition was allowed on 9/3/21.
9/3/21 is order.
Yes, my lord. Copy application was 12/3/21. It was issued on 6/4/21.
When he was asked to appear. That is important.
That is, my lord,
He was asked to appear on which date?
12/3/2028. I'll give you a lordship. Asked to appear, my lord, on 6/4/21.
That date, if that date will be the relevant date.
Yes, ma'am.
6/4.
Yeah.
ಅದನ್ನ ಇಟ್ಕೊಂಡ್ರೆ ಅಂತ.
ಅದು ಇಟ್ಕೊಂಡ್ರು
6/4/21.
15/3/23 is a writ appeal, madam.
6/4 ಇಟ್ಕೊಳ್ಳಿಕ್ ಬರಲ್ಲ. Whichever is earlier ಆಗತ್ತೆ ಅವಾಗ. 15/3.
Yes. So it is certainly more than 350 days.
ಇಲ್ಲ.
21
It is-
ಇಂದ 23, madam. Issued on 6/4/21.
6/4/21, he was asked to appear.
Yes, madam. It was given on the same day.
Same day it was given.
Yes.
6/4 ಅನ್ನು ಇಟ್ಕೊಂಡ್ರೆ
Yes.
6/4 ನಿಂದ ಯಾವತ್ತು ಫೈಲ್ ಆಗಿದ್ದು ಯಾವಾಗ? ಇಲ್ಲ 15, that is 15/3/23.
How they are calculating the 350 days is maybe excluding COVID period.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹಂಗೆ ಹೋಲ್ಡ್ ಮಾಡಿದೆ ಅದಕ್ಕೆ.
Yes, madam.
ಹಂಗಾಗಿ 350 ಆಗ್ತದೆ.
Yeah.
ಏನ್ ಕಂಡೋನ್ ಮಾಡೇವಿ ನಾವು ಅಂತವೆಲ್ಲ.
ಇಲ್ಲ. Please see, not the explanation given. There's an IA file.
Yes.
It's at page 115.
115.
At 118. ಏನು ಇಲ್ಲ, ಡೇಟ್ ಇಲ್ಲ, ಏನು ಇಲ್ಲ. Para 2.
ಒಂದು ಬೆಟರ್ ಅಫಿಡವಿಟ್ ಹಾಕಿ.
Not recently, Supreme Court, my lord, has made it very clear that, my lord, in this case, what had happened was not that merits are important. My lord, I received a certain sum of money as a non-compete fee. I disclosed it in my return. I gave a note also to say this is the reason why this is not taxable. After that, assessment is completed. And, my lord, they don't issue me a notice under 143(2), which is mandatory to go under 148. Learned judge, my lord, has relied on a Supreme Court decision. It says if you didn't issue 143(2) notice calling for information, it is not possible to issue a 148 notice. That's
on merits all right.
Merits.
Perhaps you will succeed.
But idರಲ್ಲಿ ಇಷ್ಟೇ explanation. ಏನು ಇಲ್ಲ explanation. Not I have the latest judgment day before yesterday delivered by the Honorable Supreme Court.
On merit ಮೇಲೆ ಏನಿದೆ? Merit is also one factor in condoning delay. 85, 86 Supreme Court. There are two judgments. One judgment says we will not go to merits at all unless the threshold is crossed. Another judgment says merits of the main matter are also a factor in condoning delay. There is such a judgment.
And my lord, this is 2007 assessment. Lord, imagine the plight of the assessee, my lord. He received the money in 2006 and assessment order is complete.
You had not issued notice at all.
I'll come to that, my lord. There are two sections, my lord. One is 142(1) and one is 143(2). Essentially, my lord, 143(2) is issued by the assessing authority, seeking details, explanations, and giving an opportunity to the assessee to file his, my lord, objections or submissions, etc. 142(1) also, my lord, the language used in 142(1) is where the return is made under section 139, or in case where the return is, if there are two possibilities, my lord, situations envisaged in 142(1). One is where the return is not filed under 139. The section says if the return is not filed, you ask the assessee to file the return under 139. If it is filed under 139, he will seek details. You give me the list of, you file balance sheet, give me the list of bank accounts, you explain certain transactions, etc., etc. And if the return is filed consequent to the notice under 143(1), then 143(2) would be compulsory. It has to be done because he is not put to notice or he has not been given an opportunity of being heard. You know, am I making myself clear? 142(1), it forces to
different schemes ಅಂತ ನೀವು ಹೇಳ್ತಾ ಇರೋದು.
schemes under it operates in a particular
way.
Particular way. So non-issuance of 143(2), like in this case, I'll come to that, my lord, where he says my notice issued itself, you treat it as
ನಿಮ್ಮ delay explain ಮಾಡ್ರಿ ನೋಡೋಣ.
Page 118. Paragraph 2.
118.
That's the affidavit.
ಹಾ. 117 ಇಂದ begin ಆಗುತ್ತಾ?
117 ಅಲ್ಲಿ first para is not only para 2. I respectfully submit that on receipt of certified copy of the judgment from this honorable court by standing counsel on 7/4/21, drafted the opinion and sent the entire case papers to concerned principal commissioner's office along with entire case papers. Said authority forwarded the same to concerned assessing authority to prepare scrutiny report, and on receipt of the same by assessing authority and after processing papers, forwarded papers to concerned principal CIT, and after later on, the said authority forwarded the case paper to Chief Commissioner, and subsequently the said authority forwarded papers to the Chief Commissioner Judicial, and the said authority forwarded case paper to standing counsel filing writ appeal. On receipt of paper, standing counsel informed the assessing authority, sent further document on receipt of which appeal has been filed. ಯಾವ ಡೇಟು ಇಲ್ಲ.
ಎಲ್ಲ ಡೇಟ್ ಹೇಳಿ, ಬಟ್ ಇಂಥದ್ಲೆಲ್ಲ ನಾವು ಡೌನ್ ಮಾಡಿದ್ದೀವಿ. ಕೊಡಿ ಜಡ್ಜ್ಮೆಂಟ್.
Kindly see not this.
Yes.
I gave not one judgment.
Yes.
At paragraph page 9, page numbers at the bottom, lot, para 14. We are constrained to observe that the High Court
has
exhibited complete absence of judicial conscience and restraints, which a judge is expected to maintain when adjudicating a list between the parties. Rules of limitation are not meant to destroy the rights of parties. They are meant to see that parties do not resort to dilatory tactics but seek the remedy promptly. The length of delay is definitely a relevant matter, which the court must take into consideration while considering whether the delay should be condoned or not. From the tenor of the approach of the respondents herein, it appears that they want to fix their own period of limitation for the purpose of instituting proceedings for which law has prescribed a period of limitation. Once it is held that the party has lost his right to have the matter considered on merits because of his own inaction for a long time, it cannot be presumed to be non-deliberate delay, and in such circumstances the case, he cannot be heard to plead that substantial justice deserved to be preferred as against the technical considerations. While considering the plea for condonation of delay, the court must not start with the merits of the main matter. The court owes a duty to the first ascertain the bona fides of the explanation offered by the party seeking condonation. It is only if the sufficient cause assigned by the litigant and opposition of the other side is equally balanced that the court may bring into its aid the merits of the matter for purpose of condoning the delay. We are of the view that question of limitation is not merely a technical.
Technical, it should be, otherwise it will be Damocles sword. ಇದೆಲ್ಲ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
Then
ಡಿಲೇ ಇದರಲ್ಲಿ ಡಿಲೇ ಎಷ್ಟು ಇದರಲ್ಲಿ?
ಇದರಲ್ಲಿ there was not about ಎಷ್ಟು? The number of proceedings 2,200 days. 2,200
that all entered into. That was the.
Then, my lord, there are two other cases which may not.
Order 9 rule 13 application ಹಾಕಿದಾಗ ಮಾಡಿ.
Yes. Suit dispose ಆದ್ಮೇಲೆ. Photos. Now, one more aspect is the Honorable Supreme Court has pointed out again in a recent decision that delay the appellant will have to explain from the date on which, before the expiry of the limitation, what was he doing before that time? Now kindly go to, my lord, page number 9, para 7. There is one other aspect.
Of the matter, which we must not ignore or overlook.
Over a period of time, we have noticed that whenever there is a plea for continuation of delay, be it at the instance of a private litigant or state, the delay is thought to be explained right from the time the limitation starts. And if there is the delay of 2 years or 3 years or 4 years, till the end of the same. For example, if the period of limitation is 90 days, then the party seeking continuation explain why it was unable to institute proceedings within the period of limitation. What events occurred after the 91st day till the last is of no consequence. The court is required to consider what came in the way of the party that it was unable to file it between the 1st and the 90th day. It is true that a party is entitled to wait until the last day of limitation for filing an appeal, but when it allows the limitation to expire and pleads sufficient cause for not filing the appeal either, sufficient cause must be established that because of some event or circumstance arising before the limitation expired, it was not possible to file the appeal within time. No event or circumstance arising after the expiry of limitation can constitute sufficient cause. There may be events or circumstances subsequent to the expiry of limitation which may further delay the filing of the appeal, but that limitation has been allowed to expire without the appeal being filed must be traced to a cause arising within the period of limitation. Similarly, number of days delay was 1,600 and odd days.
Correct.
And also the explanation was internal problems in the state. That was the thing. But when next judgment, their lordship say bureaucratic inefficiency should not be in the same compilation law.
Yes.
The judgment begins at page 12. Please go to page 23. Para number 29.
Begins at 12, Allah?
Yes, it begins, my lord, at
PMG,
page 12.
Postmaster
Yes,
General.
yes, my lord. Begins at 12, 2012, 3 SCC. Para 29 is relevant. In our view, it is the right time to inform all government bodies, their agencies, instrumentalities, that unless they have reasonable and acceptable explanation for delay, there was bona fide effort, there is no need to accept the usual explanation that the file was kept for pending for several months and years due to considerable degree of procedural red tape in the process. The government departments are under a special obligation to ensure that they perform their duties with due diligence and commitment. Continuation of delay is an exception, should not be used as an anticipated benefit for the government departments. The law shelters everyone under the same light and should not be swirled for the benefit of a few. But on merits, my lord, I am covered by a decision of the Supreme Court. That's what the learned single judge has followed. The issuance of notice under section 143(2) was admitted by the other side to be necessary and mandatory before the learned judge. So the learned judge applied the law.
Delay condone ಮಾಡೋಣ ಅದ್ಮೇಲೆ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಹಿಯರ್ ಮಾಡೋಣ. Application accompanying the appeal filed seeking condonation of delay is supported by the affidavit. First off, paragraph number page 118 of the application reads as under. First, learned senior advocate appearing for the SSC argues that delay cannot be treated as a technical point since policy is involved in that, and therefore the state does not deserve any leniency while considering application for condonation of delay. First, he cites the following decisions in support of such contention. Next part, having heard the learned counsel for the parties and having perused the petition papers as also the application seeking condonation of delay and having adverted to the observations, the following observations of the apex court, we are of the considered view that application needs to be favored and delay needs to be condoned. First, in the above circumstances, the application is allowed and delay is condoned.
Now, may I request your lordships to note my submission?
Yes.
That the explanation given is no explanation. That's my submission.
Learned senior advocate also tells us that the explanation offered for condonation of delay
It's very
cannot
bald
be construed as an explanation at all.
and it has no details, no. There are
And
no
that it
details.
lacks material particulars
Grateful.
as to the dates on which the file moved from one table to another.
ನಮ್ಮ ಇದು
ಸೀರಿಯಲ್ ನಂಬರ್ ಪಾಸು ಡೇಟ್ ಹೋಯ್ತು
ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 39
ಅವ್ರ ಅದನ್ನ ಹೇಳಕ್ಕೆ ಆಗೋದಿಲ್ಲ ಇವತ್ತು ಕೊಡೋಕೆ ಅಂತ ಹೇಳಕ್ಕೆ ಹೋದ್ರು ಅವ್ರು ಇದ್ದು 29 ಅಲ್ಲ
ಇವ್ರ ಸೀರಿಯಲ್ ನಂಬರ್
29 ಅಲ್ಲ ಯಜಮಾನ್ರೆ 22nd ಸೀರಿಯಲ್ ನಂಬರ್ 29 ಕೊಟ್ಟಿದ್ದಾರೆ ಡೇಟ್ ಬರ್ಲಿ ಆಯ್ತು ನೋಡು
ಸರ್ ನಮ್ಮ ಪೋಸ್ಟಿಂಗ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಬಹಳ ದಿವಸ ಫೈಲ್ ಆಯ್ತು ಹಾಗೆ ಆಲ್ರೆಡಿ ಮಾಡಿದ್ದೀನಿ ಅದು ಏನ್ ಬರ್ತಾ ಇಲ್ಲ ಮೊದಲು ಕೋರ್ಟ್ ನಂಬರ್ 6 ನಲ್ಲಿ ಇತ್ತ ಅದು ಡೇಟ್ ಏನಿಲ್ವಾ ಜನರಲ್ ಮಿಸ್ಲೇನಿಯಸ್ ಅಂತ ಹಾಕಿದ್ದೀನಿ ಸರ್ ಇಲ್ಲಿ
ಮೇಡಮ್ ಮೇಡಮ್ 3
ಹೇಳಿ ಸರ್ ಇದು ಕನ್ಸ್ಯೂಮರ್ ಪ್ರೊಟೆಕ್ಷನ್ ಅಂತ ಹಾಕಿದ್ದೀನಿ ಇದು ಸ್ವಲ್ಪ ಅರ್ಜೆಂಟ್ ಇದೆ ಸ್ವಲ್ಪ ಮ್ಯಾಟರು ಒಂದು ಮೊದಲ ಸಿಟಿಂಗ್ ಇಲ್ಲ ಅದಕ್ಕೆ ನೋಟ್ ಟೈಪ್ ಮಾಡ್ಕೊಡಿ ಸರ್ ಅದು ಮಾಡಿ ಸರ್ ಇದು ಮಿಷಿನ್ ಒಳಗಡೆ ಇದು ಒಂದು
There are a lot of compliance which are required. I'll coordinate, my lord, and whatever is required to be
The
done.
last day, we had passed an order.
Yes.
I assume that has not been complied yet by all parties.
Yeah.
I think from the government side,
the copies.
I'll look into it and immediately we'll have it done.
right, so when shall we have this?
But may I request for 3 weeks, 3 to 4 weeks time may be granted. We'll also get ready in the matter.
The memo for a withdrawal of WP. You want to withdraw that? So appeal also goes. So Janardhan, appeal will not go.
One single.
No, even if your writ petition is withdrawn, appeal by the state will not.
He wanted personally his. Because he has retired, he wanted to.
Correct, you may have relinquished your right of claiming the whatever.
Only one.
Others will survive. Appeal one date fixed, Marana. One date, as my brother said, we have committee meetings today. Important meetings are there. So other judges also come from Dharwad. Therefore, you give one short adjournment to us. On that, since you mentioned this, we have posted this matter.
Yes, grateful.
Other day. 3 weeks. Yeah.
15th of February, by then I'll look into all the, because some of the copies are not furnished, I believe.
ಇದ್ರ ಜೊತೆ ಸಂಬಂಧ ಇಲ್ವಾ? 1.94 to be declubbed. All right. 1.48.
Maybe taken up within 1 week, 2 weeks because you were
ಅಲ್ಲ ಎನಿವೇ ಸ್ಪೆಷಲ್ ಬೆಂಚಿಗೆ ಬರತ್ತಿದ್ರು.
Yes, we'll go ahead. 15.
My lord, one submission.
Sitting ಇದೆಯೇನು? Sitting ಇಲ್ಲ.
15th, sorry, 17th.
17th ಹಾಕೋಬೋದಾ?
17th.
One day. 17th start ಮಾಡಿಬಿಡಿ. Okay.
What's the issue, madam?
ನೀವೇನ್ ಮಾಡ್ತೀರಿ ಮಾಡ್ಕೊಳ್ಳಿ. ನೀವು ವಕಾಲತ್ ಹಾಕಿರಾ? ನೋಡಿ ನೋಡ್ರಿ ಅವ್ರು ವಕಾಲತ್ ಬಂದಿರ್ತಾರೆ. ನೇಮ್ ಆಫ್ ಶ್ರೀ so and so to be shown. ನೋಡಿ ಯಾವ್ದು ಅಂತ. Call this matter on 15th. 17th.
My lord, one submission, my lord.
ಬೇಗ ಬೇಗ ಹೇಳಕ್ ನಂಗೆ ಟೈಮ್ ಎಷ್ಟು ಕೊಡ್ದು ಕಮಿಟಿ ಮೀಟಿಂಗ್
1.160, my lord. My lord, we are 1.160, my lord, we are claiming benefit only for the aided period, not unaided period. It is wrongly clubbed.
It is not concerned with
not concerned with that.
ನೋಡಿ. So and so.
106.
We declare.
106, dealing.
Dealing. I have also filed memo.
Various
Memo
requirements,
ಇದೆಯಾ?
madam. We filed an impleading application. Along with main matters ತಗೊಳ್ಳಂತೆಲ್ಲ ನೀವು ಆರ್ಗ್ಯೂ ಮಾಡ್ಬಿಡಿ ನಿಮ್ಮೆಲ್ಲ ಅಲೋ ಮಾಡ್ತೀವಿ. ಅಲ್ಲ ನೀವು ಆರ್ಗ್ಯೂ you prepare your submissions. We'll hear you as if you are all parties to this ಅಂತ ಮಾಡಿದ್ಯಾ.
Filing memo also for deletion memo.
And corresponding contempt case, that is CCC number 193 of 2022 should also be delinked and called along with this writ appeal. All right. Next. ಆಯ್ತು, yield place to others. ಆಯ್ತಲ್ಲ. ಹೇಳಿ ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ? Yes, Mr. Bangi.
For the appellant, the red petitioner, my lord, the application itself has spent itself, my lord.
Does not survey.
Yes, madam.
Counsel for the appellant and new.
Petitioner, madam.
Petitioner. Petitioner.
Please.
Counsel for petitioner submits, and we agree that the subject application has become infructuous by lapse of time.
Yes, madam.
Okay. Ordered accordingly.
Please. In both the writ petitions.
Three. Both the petitions, no, no.
Please.
Order. 1 and 2.
Lord, I appear for the counsel for the
Yes, Mr.
review petition. Yes. Yes, I'm filing an affidavit. Last time your lordship had directed us to make the payment within 4 weeks.
Correct.
Well, within the time that my lord is, we have made the payment. And there's no dispute with regard to that.
ಅವ್ರು ಯಾರು ಬಂದೇ ಇಲ್ಲ.
So Matti is online.
Yes, madam. Yes, madam. I have no objection to close the writ appeal number 1000250/2021, which was not listed.
RP number.
No, RP alla. This in
Writ
writ
appeal
appeal. Lordship may kindly recall, we were put on certain terms.
Correct.
That we should pay them some category of people 50%, some category of people 100%.
Correct.
There was some delay in making the payment. So we had made an application seeking extension. By then we had made the payment. However, there was some dispute between the workers union and the management.
That's also solved.
That's also solved. We paid everybody, every pie that was due and liable to pay, we have paid. So that application which is sought for extension and that may be closed. That is not before your lordships today. This is posted because your lordship wanted to know whether we would have complied with this or not.
Order.
If we have complied with this, then your lordship said your lordship will hear the review on a particular date.
Learned senior advocate Mr. Kathavi, appearing for the review petitioner, submits that the compliance in terms of the judgment now put in review has already been done.
No. Judgment and direction dated 24/10/2024.
Judgment now put in review, coupled with the subsequent order passed by this court on
24/10/2024.
24/10/2024.
In writ appeal number. 100. 250 of 2020.
250 of 2021.
21.
Is complied with, is complied, is done. Okay. First off. The Mr. Learned Counsel, Mr. S.L. Matti, appearing for the workmen stroke union, agrees with this.
Yes.
Agrees with this. First off, ಏನಾಗಬೇಕು ಈಗ ಆ ಕಾರಣಕ್ಕೆ?
This, no, ಅದು ಆ application close ಆಗ್ತದೆ.
In view of that, the subject application.
In the writ appeal.
In writ appeal number
1002
100
of 2020.
250 of 2021 is accordingly disposed of.
Allah, close it. It was only seeking extension.
Stands closed.
Review ಹಾಕಿದ್ದೆ ಅದಕ್ಕೋಸ್ಕರ.
Review was on the main.
Review will survive.
No, his lordship was of the view that we should comply it with before this review is heard. Now we are reporting compliance so that the review could be heard.
Next one, in view of the above, post the review petition for consideration.
My lord, one date, sometime after 15th of February.
My
Not on
lord,
17th, because your lordships have posted the 17th other matter, the batch.
short date maybe I request, my lord.
ಶಾರ್ಟ್ ಡೇಟ್ ಆಗಲ್ಲ ಮಟ್ಟಿ, ಯಾಕಂದ್ರೆ ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಪಾರ್ಟ್ ಹೆಡ್ ನಾಗಿದ್ದೀವಿ. ಅದು 371J ಅದು ಇದು ಏನೇನೋ
ಹಾಗೆ. Yes, man.
2728 ಹಾಕೋಬೋದಾ?
20th.
20th ಮಧ್ಯಾಹ್ನ ಹಾಕೋಬೋದಾ?
ಹಾಕೋಬಹುದು. I mean, it will not take much for admission because certain things will have to be redefined only by this, your lordship, this bench only, because it, my lord Justice Pradeep Singh Yero did not have the benefit of hearing because it was heard by your lordship sitting along with his lordship Justice Krishna, but as he then was. So we may have to start afresh.
Correct.
Though your lordships have
But
decided.
he comes after reading.
No,
Generally, I do not read, but he comes after reading.
No, my lord, I have appeared in a number of matters. No, I have appeared before, as I've appeared before lordships, I've also appeared. What I'm saying is, the facts of this case, because it is at the appellate stage that the matter was.
Very well, agree.
My lord, which date?
27th afternoon, Mr. Matti.
Yes, my lord. Which month?
27 afternoon ಹಾಕೋಬೋದಾ?
Yes, my lord. 27th of this month.
Next month, not now.
On submission.
My lord, in writ appeal number 2476 of 2015, my lord, I have filed impleading application, my lord, as a respondent number R3 and R2 R19, my lord. It may be allowed, my lord.
ಅವತ್ತು ಆರ್ಗ್ಯೂ ಮಾಡಿ ಹೇಳಿದೇವಲ್ಲ, ಈಗ ಅದ್ರ ಮೇಲೆ ಆರ್ಡರ್ ಆಗಿದೆ ಈಗ.
ಕೊಟ್ಟರು 17 ಕೊಟ್ಟಿದ್ರು, 17 ಕೊಟ್ಟಿದ್ರು ಆಗ್ತಿತ್ತು. ಇನ್ನೊಂದು ಬೆಂಚ್ 17 ಕೊಟ್ಟಿದ್ರು, 10 ಕೊಡ್ಲಿಲ್ಲ. ಫೆಬ್ರವರಿ 7 ಎಷ್ಟು ಯಾವ ಕತೆ? ಶನಿವಾರ ಗುರುವಾರ ಫೆಬ್ರವರಿ ಅವರು ಕೋರ್ಟ್ ಆಫೀಸ್ ಬಂದ್ ಮಾಡಿದ, ಕೋರ್ಟ್ ಇದನ್ನು ಬಂದ್ ಮಾಡಿದ, ಮ್ಯೂಟ್ ಮಾಡಿದ.